to Legally Speaking. With me, Tarun Nangia. Now we commence the part 2 of our series on, first of all, congratulating the 5 new members. Of course, the 3 judicial members and the 2 technical members who have been appointed to the National Company Law Appellate Tribunal, as well as the suggestions that the eminent panelists who join us also in part 2 would like to give. But I have to read out the names that have been appointed. Justice Rakesh Kumar Jain, Justice Rakesh Kumar, Justice Satya Narayana Murthy, they have been appointed as judicial members to the National Company Law Appellate Tribunal. As Barun Mitra, who's an IAS officer, and Naresh Salecha, who's an IRAS officer, they have been appointed as technical members. Now we continue our round of suggestions. At the outset, I would like to ask my panelist Mohit Saraf on the training issue, because you have been training judicial officers and judges at the Bhopal Judicial Academy and other places. Justice M. Kumar said something. Do you concur that industry experts should come and train the appointed members so that there is a certain updation of how businesses function and what leads to NPAs and why quicker resolution is important? What all are the problems that companies face if a takeover gets delayed? All of these things, your opinion on that?
I would say calling these as a training program will be probably not an appropriate word. Okay. What you require is an interaction. I think when we go to the National Judicial Academy, what we do is we give because I have worked with the World Bank on some of the infrastructure projects. So what we really share is our experience. And therefore, they're able to understand why delay kills project. And because we are working very closely with banks, others are not. So it's more of an interaction and sharing experience. And as Justice Kumar said, that really you can't get theoretical. You need to give them the real life problems and give them the real life solutions. Not solutions, but experiences. And I would say every such program, I have myself benefited a lot. I'm sure judges also have picked up 1 or 2 things from our experience, from our cross-border experience and cross-culture experience. So I would say and that should continue. In my view, for IBC matter, interaction with IBBIs, interaction with lenders, interaction with private equity funds, and professionals, lawyers who work on this area should continue. And that is an important part, because I think sometimes when you are looking at so many cases, you are not able to understand the time is the essence issue. That what it impacts, how it impacts the economy, how it impacts the poor people. And the judges are actually looking after those poor people. And they don't know indirectly it actually affects them so badly. Like one of my discussion at the National Judicial Academy, when I was talking to almost 30 judges, sitting judges of High Court, I explained that how a delay in infrastructure project delays improvement of productivity and poor stays poorer. And they are always looking at those issues, marginal people. So this is again, when you look at an infrastructure project and you start thinking about, this is a developer, is a big guy and the government, and you miss the benefits which it accrues to the society. And therefore you lose the focus. I would say that is an important thing. And that interaction should continue. And again, I think every time I come back, I learn so much from judges, because the way they look at law, we know how to argue, but it is very important for us to know how they think. And that's an important part. So it will actually benefit the bar as well as the existing judges. And because NCLAT is so specialized, I think the much more interaction is required at the NCLAT level, be it competition, be it IBC matters, be it companies matters. Because I think, as rightly said, delay in open offer, all these things, if you see, the matters get delayed way beyond. And sometimes the subject matter is dead. And because it's just lost its relevance. So some of the matters, when there are open offer which is delayed, it's been delayed for years. And the judgments have not been pronounced. So I would say some of these things are very important for justices to realize, and that is an interact that can help. the interaction where the bar, the members who understand these issues can share their experience, and then the both will benefit.
Thank you for that comment. I'll go to Mahesh Agarwal, Managing Partner of Agarwal Law Associates. Now, in appeals against orders of admission of the corporate insolvency resolution professional, an opportunity should be given in every case to settle within a fixed period with necessary interim orders on constitution of the COC. After lapse of a fixed period, no interim order should be passed and the process should be allowed to continue. Do you agree with such sort of a setup?
See, I would say there are two stages broadly in which the appeals come to NCLAT. First stage is where an IBC petition is admitted, and either the corporate debtor or the promoter, somebody challenges it. So it is at a stage when the process is yet to start, but the admission of the case is itself challenged.
Yes.
And second is cases where the resolution plan has been accepted by the COC, it has been accepted under 31 by the NCLT, and then they come. So these two stages have to be dealt with in completely two different manners. So far as first is concerned, where the promoters are challenging or the corporate debtor is challenging, I think at that stage, to expedite the process and expedite the resolution, a chance must be given to the promoter to resolve and settle. In fact, pursuant to a judgment of the Supreme Court in Swiss Ribbons, Section 12A was introduced, which gives a jurisdiction to NCLT to close the matter on settlement. So settlement has now been accepted even by the Parliament. Now, having said that, at that stage, if an opportunity is given to a promoter or a corporate debtor to settle the debt, and the banks accept the settlement, that will avoid several years of litigation. Okay. Now, where the plan has been accepted, there the focus should be on implementation. You can admit the appeal, the hearings can go on, issues can be decided, but the implementation should take place. What happens is, if the implementation is delayed, who suffers are the employees, all stakeholders. In fact, banks also suffer because whatever has been promised to them, say in 2021, if they get in 2023, nobody gives them interest.
Yes.
So they're actually losing out. So therefore, two stages of matters have to be dealt with separately.
Point very well taken. I'll go to Ruby Singh Ahuja, Senior Partner, Karanjawala and Company, for a comment.
On this issue, you want me to comment on this issue of
this and training, both issues.
See, I think I agree that training may be a misnomer. We don't need to use the word training but I certainly feel that there has to be more interaction. So there in India, it is especially, there is something like that bar is here and bench is here and the twain shall not meet. Because of our protocol, we are more formal, if I may. So we don't have sidebars, and the judges cannot call suddenly two people into their chambers to discuss. So which is very good, which has worked for us, and I don't think so we need to ape anybody. But still, I think there needs to be more interaction. Having an interaction once in a while over a seminar or a honorable judge's farewell party doesn't lead anywhere. So yes, of course, if the bench and bar can speak to each other, or maybe some sessions can be held where people can tell the problems they are facing, even for the implementation or day-to-day problems. Like Mohit said, it is a very big problem that you can't file anything without mentioning. So it is a huge issue. Now, I don't think so anybody has brought it to the notice of the honorable members that maybe that notification came in some circumstances, maybe those circumstances are not here now. We need to change them. And secondly, this virtual. So if practical difficulties also somebody can approach, even people who are practicing there. So this will help to a large extent. It won't be a training, but it helps judges to implement their decisions looking at the practicality of the situation. Now, as far as that whether any interim relief should be given or not at the first stage, rightly, yes, of course, when a company is admitted into insolvency, yes, their appeals are filed. Yes, of course, people should get a chance to settle. But I certainly have a view that once the plan has been approved, this settlement chance should not be there. And I'll tell you why. What happens that one business house looks at one venture. It's a steel company. They are into steel business. another steel company is going into insolvency. You're spending your energies, you're trying to come up with a plan which the COC will approve. Now, suddenly somebody goes and says, excuse me, I want to settle. And if 90% of the COC says, yes, I will settle because there is 12A. That is where I have a problem, because what will happen that if this is allowed to continue, the serious entrepreneurs will not come in the front because they are wasting time, money, energy, losing a business opportunity. They thought that they are going to, make a plan here. They may not be making a plan somewhere else. So there I certainly feel that where it will be settled and where it will not be has to be looked into business. But you may have a right in law. I don't know whether the 12A is rightly implemented, not implemented. The honorable judges will decide, but the judges will also have to decide from the business perspective also, because entrepreneurs are, you can't be expecting people to come forward and start bringing companies out of insolvency if every time everybody has to go to court for a little small thing. So I think there I certainly feel that settlement cannot take place. And yes, no interim relief. There I agree, because you lose the value of the asset, because we cannot shy away from the fact that we do have a pendency problem. We do have a delay problem. Even the best of the judges with the best of the intent find it difficult to dispose of cases. And if something in a commercial world is pending for 6 months, 1 year, it loses the value for that businessman. He is not interested. People have come to me and said, I wish this plan should not be approved now because this asset has no meaning for me now. So I think that...
I want to add one comment here. Maybe at this stage, I should tell you one comment because it's a little different than what Mahesh said and Ruby said. After a matter is admitted, because pre-admission, there are enough chances for promoter to resolve it. After the matter is admitted, the scheme does not allow any consideration to be given to the promoter. And I think that is, in my view, we should follow as a gospel. Because a pre-IBC, like one of the comments which Mahesh had earlier made, a lot of matters are getting settled pre-IBC. So once the matter is done, the only provision, and same thing is with the resolution plan, once approved, there's no way the promoter should be given back a chance. The only thing what is provided is under 12A, when 90% of the COC agrees with a plan, and it does not get the benefit of our IBC, there's no whitewashing, then they can withdraw. And that is the commercial wisdom. I don't think that you can take away. And that's the reason the threshold is 90%. But there's no 90% is nothing to do with the promoter. It's something because they're not getting a good deal and they got a better deal and they can do that. So I would say promoter should lose, and that is the scheme. 29A is that scheme. Once the matter is admitted, the promoter is out of the company. That's the scheme of the thing. And therefore, they should not be allowed either after admission or post-resolution plan to come up with a plan. The only way is 12A. If 90% of the creditors agree to withdraw, that's a separate issue.
One second, if suppose you take a company, it's admitted to insolvency, you know that IBC has far-reaching, very serious consequences for, and if the promoter who has built his company for years, now for some reason, let's not get into the reason, it has gone into the verge of insolvency and the bank has taken it and it is admitted. And at that stage, a promoter, mind you, I'm not saying before the resolution plan, after the resolution plan is approved or is before the COC for voting. Before that, where nobody has spent time, energy, and even the EOI has not been issued, if at that stage some promoter wants to settle, why not? You can't, I mean, after all, it's his asset. You can't take away the fact that you are taking away his asset under a stroke of a pen. The rights of the promoters have been diluted, though I'm all for the recovery from the banks, but I cannot be unmindful of the fact that the rights of the promoters have been taken away to a very, very large extent under the IBC court.
I just need to say this, just to clarify, 1 minute, yes. I just need to clarify. So this is exactly what I said. There are two stages of appeals. Where a resolution plan has been accepted, there is no question of any settlement. Plan must be implemented without any... Where the initial order is challenged before the NCLAT, at that stage, one last opportunity should be given, and after that is over. Once the resolution process starts, there is no question of any further offer, settlement, etc., etc.
Because I pitch it that high, Mohit, that as Mahesh rightly said, before, one last opportunity, because somewhere you're striking at the promoter's fundamental rights also.
In the real world, I can tell you, I work for banks pre-IBC also. In the real world, the promoter gets 100 opportunity before the matter gets admitted. And after that, the deal is over. That is the reason why 29A is there. Another order is basically only increasing pendency, and litigation eventually will not solve the problem. Since we are here to improve efficiency, not to find ways of destroying value, that's the reason I thought that
I'm liking this so much that me and Justice M. Kumar can just take a walk. I don't need to moderate Justice M. Kumar. I'll go to Justice M. Kumar for his comment.
Yes. Tarun, I think very lively discussion. As far as the last part of the discussion with regard to exit of the corporate debtor, I think after admission, 90% COC voting share is in favor of withdrawal. It can be withdrawn, but it has to be before floating the expression of interest. That limitation is there. And in the otherwise, I think in Swiss Ribbon, Justice Nariman has explored 4 exit points: pre-admission, post-admission, and even post-liquidation. There was a regulation 39, if I remember correctly, that even during liquidation proceedings, the corporate debtor can purchase at a rate which may be acceptable. That was also an exit point. Having said that, I think the idea is to give some peace to the prospective resolution applicant. Otherwise, there will be a lot of discouragement. Nobody will come forward, and the haircut would keep on increasing if the process is to be reinitiated or it is to go into liquidation. So I remember I passed an order where I said that if the value of the asset is less than the liquidation value, the value of the asset is equivalent to liquidation value, and the resolution plan comes which is less than the liquidation value, then I rejected the resolution plan, allowed the liquidation to go on. But Supreme Court said no. Even if a resolution plan quotes less than the liquidation value, tribunal cannot say no. It has to accept. So the idea probably was that the industry, the company should survive, workers should survive, and it will be in the larger interest of the society. Probably that might be but my outlook was that it should, it should not be less than liquidation value. At least the creditor should get that much. Now, the other issue with regard to the imparting of some education to the member, I think in the first part I have said that collegium system can work very well. Member can interact between themselves. Then, of course, they can invite any good entrepreneur also. They can be guided, their problem can be heard by them. And even good lawyers should be invited to, you see, when I started the collegium system in the NCLT, I invited 2-3 big firms and the lawyers practicing. Then I received few letters objecting that how you have invited the lawyers who are practicing before you. Then you see, if you go to England, lawyers of both sides at least at the time of argument, they exchange notes. And while exchanging notes, they narrow down their argument. This issue is covered by the Appellate Court of Appeal judgment. This issue is covered by the House of Lords or now Supreme Court judgment of England. They don't argue on those issues. Ruby has, in the first part of the discussion, has mentioned that we must improve the bar, the standard of the bar. I think it is a very good idea if the lawyers start exchanging notes and they narrow down the issues of argument, because if a judgment or a statutory provision or a subordinate statute like instructions, regulation, rules cover a particular point, then no use arguing before the bench. But the difficulty is that I, having practiced for 24 years plus, I know the client is always on your head. And sometimes you, in your enthusiasm to serve the client, you may not like to, exchange notes with the opposite lawyers. But I think if we are able to develop that type of bar, especially in specialized tribunal like the NCLT, NCLAT, I would welcome that type of step. And I think whatever exposure the members of the bench have, they must develop sense of justice. Sense of justice is one thing which must be instilled amongst the members of the bench, whether judicial or technical. You see, Parliament enacts law by keeping the society as a whole in front. But the law is tested when individual approach the court and try to argue that the law does not provide for the situation he has landed in. There the role of the judge, who has developed sense of justice, comes in abundance. That sense must be developed. That sense can come with experience. That sense can come with regular meeting and exchange of notes amongst the members of the bench, as well as they can have eminent people from the bar also. Remember, the bar has a great potential. Bar, theory of basic structure of the constitution could not have been laid down had there been no Palkiwala. It was possible only because of eminent lawyer like Palkiwala. So there is no dearth of talent in the bar. So it should be welcome if they are prepared to come and exchange their knowledge with the member, because it will help them in developing the sense of justice. Justice Krishna here used to say that law and justice must be on talking terms. If a law does not administer justice, I remember a few cases which I decided in Chandigarh as a judge of the Punjab and Haryana High Court, or in Jammu and Kashmir, where I thought a judge must have all the instrument in his armory to reach injustice wherever it lies. So that type of armory, those type of principles, a judge must be clothed with. He must be very rich in his knowledge so that he may use. I remember deciding a case of a sick woman, blind woman, hard of hearing woman, who ended up thumb marking a deed for 99 years of her land, which in fact was meant for 1 year. And the courts below, sub-judge as well as district judge, held that she is bound by that deed. But I reversed that. The reason, I said there is a principle of non-est factum. And principle of non-est factum and the Pardanishin woman, the onus of proof shifts. When I shifted the onus on the defendant, they had no case.
Thank you. Thank you so much for sharing this perspective with us. And I'm glad you brought up Nani Palkiwala. In fact, he was generous enough to go to Government Law College and taught there till 1953, following which he stopped teaching there.
Yes.
I think that was towards the time Soli Surabji took admission in GLC. That was those days in Government Law College, Bombay. But yeah, that's about it. I mean, this is a wonderful, wonderful two-part series I got to do. And I was glad that, there was point and counterpoint and being generated without me asking question. That really means that the panel was engaged with each other. And thank you. I would like to thank Justice M.M. Kumar, First President, National Company Law Tribunal, Ruby Singh Ahuja, Senior Partner, Karanjawala and Company, Mohit Saraf, Managing Partner, Saraf and Partners, Mahesh Agarwal, Managing Partner, Agarwal Law Associates, for making time joining us for this two-part series, but doesn't end there. Issues with the implementation or the non-implementation of the resolution plan remain, which I think will trouble us for some times to come. There are many important matters stuck. We will like to take up those matters in another fortnight. These members have just taken oath. I think fortnight or a month is at least the time that is required before we take up those important cases. But bye for now. Thank you so much for joining in.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.